Hello, everyone who's joining in right now for the webinar. We're going to wait till about 1 after the hour and let everyone join, and then we'll begin. So until then, please everyone mute your lines, and we'll get started shortly. Hello, everyone. Welcome to the webinar, Pandemic Issues and Commercial Lines. First of all, we'd like to welcome you on behalf of the Association of Insurance Compliance Professionals and AAIS. In case you're not familiar with the AICP, as we like to call it, the AICP, the mission of the organization is to serve the insurance compliance community by promoting relationships, exchanging information, and providing learning opportunities in a dynamic regulatory environment. The AICP has over 1,400 members representing over 500 different organizations, including insurance companies, regulatory bodies, and service providers. We're split into 9 regional chapters, and today's webinar is brought to you by the Gulf States chapter and the AAIS. Next slide, please. The AICP and AAIS are committed to operating within the letter and spirit of all applicable federal and state laws, including antitrust laws. While this presentation discusses several legal issues, including pending claims and litigation, the information provided and opinions expressed during the presentation do not constitute legal advice and should not be relied upon as such. With that, I'm happy to pass it over to Lori and to begin the webinar. Thank you for attending.
Good morning or afternoon, depending on where you are coming from today. I just want to cover a couple housekeeping items before we jump into the presentation. First, please mute yourself, and if you can, also have your camera turned off. That'll help with the quality of the sound. Also, during the presentation, feel free to ask questions. You may use the chat function to ask questions, or at the end of the presentation, the presenters will also ask for verbal questions at that time. With that, I'd like to, on behalf of AAIS, thank AICP and the Gulf States chapter for hosting us today, and we're going to jump in. Today's panel is made up of 3 members of the AAIS COVID-19 Task Force, which is responsible for providing our members up-to-date legislative information, proactive responses to regulator requests, and developing innovative product solutions. Joe Jonas, Commercial Lines Product Manager for AAIS and moderator for today's discussion, will be joining. With that, we'll have Nicole Milos, Assistant Counsel at AAIS and Regional Attorney for the Midwest region. We also have Phil Skaggs joining us. He is Assistant Counsel at AAIS and Regional Attorney for the Northeast region. With that, I'm going to turn it over to Joe to kick off the presentation. Thank you all again.
Lori, thanks so much for that introduction, and a special thank you to all of our attendees. We actually held a webinar a few months ago to discuss the pandemic and insurance. And really between that time and now has really given us all new talking points. The onslaught of COVID-19 litigation is not surprising because whether economic crisis, significant weather event, act of terrorism, we recognize that disasters breed insurance litigation. However, COVID-19 is different because COVID-19 is a global pandemic that has severely impacted businesses in every industry across the world. Further, unlike national disasters such as hurricanes, tornadoes, wildfires that impact a limited number of policyholders for a limited period of time and in a limited geographic space, pandemic losses, by definition, have the potential to impact a majority of policyholders, irrespective of location, and at the same time, with losses continuing over the span of months or even years. Therefore, the responsive litigation has been and will continue to be larger than any prior historical crisis. And to help define what that scope really looks like, Nicole, can you start us out by putting it into perspective?
Absolutely. Thanks, Joe. AAIS has been tracking litigation, and if you go to the next slide, we can show how we've developed a COVID-19 tracking dashboard for litigation. And as you can see by this slide, this tool allows you to visualize where the litigation hotspots are, and you can see the industry sectors by litigation case count and search specific litigation cases and links to the pleadings. Now, by way of some general information, as of September in the United States, nearly 5,000 COVID-19 complaints had been filed. And of the nearly 5,000 complaints filed, the most common category of filings involves insurance, with nearly 1,200 COVID-related coverage cases on file. The states that have the most COVID-related insurance complaints filed are California, Pennsylvania, and Florida. And in the vast majority of the cases, being insurance and coverage cases, the plaintiffs are seeking coverage for business income, extra expense, or civil authority coverage. Interestingly, only approximately a quarter of the COVID-related insurance and coverage cases filed actually allege bad faith.
And as Nicole mentioned, we're seeing a large number of insurance and coverage cases. You may already be aware of the multiple lawsuits by restaurants and bars, but I think it's also important to note here that the cases actually span several business segments. So roughly a third of these cases filed to date involve the food and beverage industry. However, we're also seeing some litigation pertaining to performing arts, spectator sports, clothing outlets, real estate, specifically landlord-tenant disputes, amusement and recreational industries, and of course, professional and healthcare services.
So, Nicole, you made mention that we've seen 5,000 COVID-19 complaints. Are you seeing any trends in the claims that are being asserted by the plaintiffs or arguments being raised in response by the defense?
Sure, I'll let Phil address the arguments that are raised by the defense, and I think we'll keep our comments limited to those insurance and coverage related cases. But as far as the arguments asserted on behalf of plaintiffs, we're seeing the argument that the inability to use property as it was intended constitutes direct physical loss or damage. A spin on that argument involves the claim that some plaintiffs are saying the virus poses a specific threat to property, resulting in physical loss to the property. Another argument alleges that the precautionary measures taken by federal, state, or local authorities to prevent the spread of the virus is a proximate cause of the loss. Similarly, some are arguing that civil authority orders represent a physical loss to property, and alternatively, some are arguing that the statements made by federal or state officials that the pandemic constitutes physical loss support an argument for coverage. The final argument that we're seeing with relative consistency is that the insurance industry has denied claims on a wide-scale basis without any reasonable investigation. Phil, do you want to address those defense arguments that we've seen?
Sure, Nicole, thanks. Just as there are trends in the arguments in favor of coverage, we're seeing corresponding trends in carrier defenses. The general premise, though, is that there's just a lack of evidence, scientific or otherwise, of direct physical loss or damage necessary to trigger policy coverage. And there's three kind of specific arguments underneath that. First, the mere possibility or suspicion of the existence of COVID-19 does not constitute direct physical loss or damage to tangible property. The lack of access or inability to utilize a premises does not by itself constitute direct physical loss or damage. And the civil shelter in place and business closure orders, they're not specific to the covered property and thus are not in and of themselves evidence of the presence of coronavirus or direct physical loss at the covered property.
So I don't think we're going to have enough time to review all 5,000 of these filings. So in lieu of that, Nicole, Phil, maybe you can each provide some of your greatest hits, so to speak.
Sure. There's a variety of class actions that have been filed across various industries, including consumer claims in California against Target for allegedly misrepresenting that its store brand hand sanitizer kills 99.99% of germs, which was not backed up by any reliable scientific studies. Interestingly, competitors of Target and other sales retail groups appear to be well aware of these claims, as we're seeing companies seek to avoid claims by including strongly worded disclaimers on their websites, and those same companies sponsor product disclosures that state that their products, quote, meet the EPA criteria for use against the cause of COVID-19 without going so far as Target did. Independent bloggers for the products and media tend to run with the attention-getting headlines and stick with that product. This product kills 99.9% of viruses, which still may cause those companies to get in some trouble.
Right, and I'll add that also on the consumer side of things. I'll be a little more scattershot here. We're seeing class actions filed against airlines for refusing to honor ticket refund policies for canceled flights. There's also a few actions filed against online ticketing services like StubHub and Vivid Seats as a result of event cancellations. We've seen Grubhub sued and other food delivery apps for unfair pricing during the coronavirus pandemic. And then to bring it back to actually the hand sanitizer suit against Target that Nicole mentioned, there have been suits filed for price gouging surrounding the sale of toilet paper and hand sanitizer and personal protective equipment, all that stuff, the N95 masks that were hoarded at the beginning of the pandemic. So kind of, it encapsulates a lot of different categories, but it's all kind of follows that same thread of misrepresentation or failing to follow your own policies and so forth.
We've also seen a lot of claims filed in the cruise ship industry, including claims from passengers that the cruise line negligently failed to utilize proper screening protocols for COVID-19 prior to boarding passengers on the ship, as well as failing to warn them that passengers from a prior trip had experienced COVID-19 symptoms. In other suits, we've seen allegations that the cruise line accepted passengers despite knowing that some exhibited COVID-19 symptoms, that the ships were not sanitized properly, that the passengers were told that they would not be refunded if they canceled due to fears of COVID-19. Interestingly, and on another issue, the Paycheck Protection Program loans have been in the news a lot, and our audience might find it interesting that there's been a series of class action suits that have alleged that the banks prioritize larger loans instead of handling the application on a first-come, first-served basis. And I know, Phil, you mentioned earlier those labor and employment cases, so we would be remiss if we didn't, specifically call out the just exponential amount of unlawful termination claims alleging that there was a failure to protect workers, a failure to give adequate notice of termination, or refusing to pay previously agreed upon wages.
Yeah, sure. And speaking of our audience, I'm sure they would like to hear some more details around the insurance and coverage cases. Nicole, can you just take a few minutes here to discuss some of the more attention-grabbing cases?
Sure. To start off, we should probably focus on those broker cases. So if you want to go to the next slide, in the Magna Legal Services versus Hartford and Nottingham Agency claim, Magna filed suit following the denial of coverage for a claim of more than $50,000 in lost income during the government-ordered shutdown. The carrier argued that the policy excluded coverage for income lost during the pandemic, and Magna countered that the broker never explained the coverage, that coverage for losses related to viruses, pandemics, or related orders of civil authority were excluded. Now, interestingly, this suit was later withdrawn, but a similar factual scenario led to a case being filed in Texas. And in that case, the court held that the policyholder did not state a recognizable claim against the broker. And the case was dismissed, with the court holding that the claim against the broker sought damages that were not compensable under Texas law.
So you touched on an interesting point there, and reminded me of a previous life when I was on the consulting side, and further reminded me of a situation with Superstorm Sandy. After that event, we saw a scenario unfold where insureds were filing suits against brokers because they were alleging that they were not offered flood, or advised that the policy excluded it. Is this a similar situation playing out here against the brokerage community, or for alleged not offering or not advising?
It's interesting, Joe, because we're just starting to see this. What I expected to see when the pandemic started is not actually what I'm seeing. Although we've seen 5,000 COVID-related cases filed and approximately 1,200 insurance coverage-related cases filed, when you consider the significant economic impact and geographic impact that this pandemic has caused, the number is not nearly as high as I anticipated. What I am seeing, however, is what could almost be described as test cases. In other words, cases that are being filed in specific jurisdictions by groups of plaintiffs or specific plaintiffs, testing how different jurisdictions will rule on specific arguments. And I'm also seeing that when pleadings motions are resolved unfavorably for the policyholder, to the extent that it is procedurally possible, the cases are being voluntarily dismissed. So in light of that early trend of favorable decisions for the carriers, we've seen an uptick in the amount of complaints against other possible culpable parties like the brokers that we started talking about. In fact, last week, there was another complaint filed against a broker, and I think that complaint is really demonstrative of the allegations that we're likely to see going forward in the broker realm. That complaint alleged, like you described, the broker acted as an advisor of insurance needs, the broker had expertise in insurance, the broker was responsible for receiving applications for insurance and reviewing the client's specific information, and the broker had access to and reviewed all the existing coverages, advising whether the current coverages were sufficient or whether additional coverage was needed to cover all aspects of the business. The allegations claim that the client relied upon the broker to identify coverages that were important and relevant to their business needs. Interestingly, in many of these cases, the allegation is made that the client asked whether there were any missing coverages or gaps in coverages, and the broker, it's alleged, failed to identify these gaps for pandemic or virus-related claims. Ultimately, the complaints allege that as a result in the gap in coverage, the client sustained a loss.
If I may say something here, I also think another interesting issue will be whether these plaintiffs can establish damages directly related to the purported failure by the broker. Generally the claimant must prove not only that the broker made some sort of mistake or misrepresentation, but also that the claimant, would have acted differently if they'd actually been given more information. In other words, could they and would they have purchased pandemic coverage or gap coverage if they've been offered? I think a lot of evidence in the market currently points the other direction. Gap filling products and options were available, but just were rarely or really never purchased.
So we know that plaintiff attorneys are pursuing a variety of avenues to file suits, as plaintiff attorneys tend to do. But what about rulings or substantive rulings? Has the court issued any? And if so, can you speak to those decisions?
Before we get to that, Joe, I think we might want to mention, in support of Phil's point, the argument with regard to pathogen RX that I know that you're very well versed in. Certainly, that product had been on the market before this pandemic. And in fact, the sales of the product demonstrate exactly what Phil was speaking to, that the product was not purchased. So I think that Phil makes a very good point with regards to the brokerage cases or the possible defense for the broker cases, because there was a product available and no one was purchasing it. So I think that's really interesting. Another point that I think that we want to make sure that we mention and people are curious about are the efforts to group claims together. We've seen several requests that have been filed asking federal courts to centralize federal COVID insurance-related cases in a single court pursuant to multi-district litigation. A large number of policyholders have argued in favor of instituting an MDL, while, of course, the insurance industry has opposed it. The requests have been brought in federal courts in several jurisdictions, including Pennsylvania, Florida, and Illinois. In general, the courts so far do not seem receptive to the MDL petitions that seek to centralize all COVID insurance claims, regardless of policy or carrier. However, a recent opinion left the door open to a possible insurer-specific MDL. And using another procedural mechanism, we've also seen attempts for consolidation. And in fact, the plaintiffs were successful in consolidating 4 actions that were filed in 3 different Pennsylvania counties against the same carrier. Those were all consolidated into one state court proceeding in Pittsburgh. The court, interestingly, ordered that the insurer is to identify any other actions concerning its denial of business interruption coverage so that the court could consider transferring those matters into the consolidated case as well. Now, going to the point that you raised with regards to the status of decisions, if we go to the next slide, you'll see that there's been several rulings in favor of the carrier. In fact, the courts have ruled for the carriers in state courts in California, Michigan, and DC, as well as federal courts in Texas and California. The first substantive dispositive ruling on COVID-19 related business interruption claims occurred in July in Michigan. Now, this chart shows you the date of the decision, the jurisdiction, and the case name. And I should note that the opinions and orders are coming in fast and furious. In fact, just yesterday, we have not updated the chart, I apologize to say, the Northern District of Illinois issued an opinion and order in the Sandy Point dental case. And in that case, the federal court dismissed the case, the pleading, and found that the closure of the dentist's office due to the state's order did not constitute a direct physical loss. And that's a bit duplicative, if you will, of the decision that was originally reached in Michigan. The first one you see there, Gavrilides. The court there held that there must be some tangible physical alteration of the property to qualify as direct physical loss of or damage to property, and that being physically restricted to access the property would not suffice. It's also interesting to note that in that case, the court ruled that the policyholder had failed to establish the inapplicability of an exclusion for loss caused by virus or bacteria.
So for me, I'd like to highlight Greenwich Insurance Company, that case at the fourth one down in this chart here. It's the first federal case to really kind of carry this trend that we're seeing forward, and kind of stands out for its representation of the momentum of these cases. The court again focused on the application of direct physical loss or damage language in the policy, and then determined that the emergency government orders in question, which effectively forced the policyholder to close their business, were indicative of an economic loss, but did not demonstrate that actual tangible physical property loss. And why this is important is because what we're seeing is, courts are resolving coverage based on this language alone, and then never reaching the application of potential virus or bacteria exclusions that may be attached to the policy. Very important trend for carriers, especially those policies that do not clearly exclude virus or bacteria as a cause of loss.
So, I think based on your answers that we can ascertain for the most part that decisions have been relatively favorable for insurers. But one case that I'm aware of is the Cincinnati case that seems to favor the insured. Do you have any thoughts on that decision?
Sure, Joe, if you go to the next slide, you'll see that we have called out here the Studio 417 decision and the Optical Service USA decision. In my view, these decisions actually operate as a bit of a red herring. The 417 is a federal case where the court denied the insurer's motion to dismiss the coverage claims of a proposed class of restaurants and hair salons. It's a pleadings motion that was not dispositive. Therefore, the 417 case like the ruling in Optical Services USA, are not substantive coverage rulings. The carriers in these cases did not prevail on the pleadings motions, but coverage has not been decided.
So, I know as lawyers here in the States that you follow litigation very closely, but there's been a ruling in London that's raising some eyebrows. Are you familiar with that?
Sure, I can speak to that. So that's the third case listed on this slide, the Financial Conduct Authority case, or the FCA, which is an independent public financial regulatory authority in the UK, which often takes on the role of kind of a consumer watchdog. And so in the wake of the massive COVID insurance claim denials in the UK, the FCA filed what they call a financial market test case, asking the court to interpret several sample policy wordings and then determine whether coverage should be provided. The case named 8 insurer defendants, some of which you might be familiar with, Arch and Skaggs and Zurich, and considered about 21 different sample policy provisions. And after hearing in July, the court concluded that the majority of the policy clauses that they reviewed did indeed provide coverage for COVID-19 related business interruption losses, with some variations, depending on the insured location and scope of business. So what's interesting about this case, though, is the various opinions on what it means for the larger insurance industry moving forward, including the U.S. market. Not surprisingly, the FCA and policyholders have chalked this up as a big win, claiming that the decision provides, so much needed clarity and requires coverage. But the defendants and other insurance companies are pointing to two different but important takeaways. First is that the decision did not hold insurers liable for all 21 different sample policy wordings. In particular, Skaggs stated that the decision provides clarification for, I think, less than a third of its 30,000 plus business interruption policies. So, and then Zurich also has stated that the decision simply affirms its own policy interpretations, how it has already been issuing coverage and making decisions on coverage to date. So, and then the second takeaway, which is I think important for most people on this call, is that the case did not discuss the key point in the U.S., which is whether COVID-19 constitutes or causes direct physical loss. Instead, it focused on whether the UK's governmental actions constituted a mandatory denial of access, which is similar but not identical to the civil authority provisions in U.S. policies. So it's unclear as to whether there would be any appeals, but this is certainly a case to keep an eye on for further developments and interpretations and those takeaways. That it doesn't compel carriers in the U.S. to then start reanalyzing their coverage decisions.
You're absolutely right, Phil. I think the main takeaway here is that we agree that although it's interesting, the FCA decision is not inconsistent with those precedent decisions that we've seen issued in the U.S.
Yeah, I was just gonna, say that given the relationship between the London market and the States, and certainly you rattled off some big names on the insurer side, we'll be keeping a close eye on that. And one thing I don't know if it was mentioned, but something that came to mind for me as the legal landscape really began to unfold, the issue on silent language. It's top of mind for me because we're starting to see this with silent cyber. And there was definitely some initial concern that courts would find coverage when cases involve policies that were silent on the issue of a virus or bacteria or communicable disease. What are your thoughts on the silent policy concerns now that the courts have started issuing rulings?
Phil mentioned this briefly earlier, and I agree. In the spring and early summer, when we were predicting the coverage arguments, we, like many others, believed that the courts would focus on the language that affords coverage, would not focus on the language that affords coverage for direct physical loss or damage, but would instead focus on the exclusionary language. We believe that the heart of the debate would revolve around how courts were going to apply virus or bacteria exclusions or the communicable disease exclusion. And in fact, as you correctly mentioned, in the early days of the pandemic, many expected that policies that lacked that exclusionary language, or silent policies as you described, would not prevail when the coverage was examined and challenged. But it has really turned out to be the opposite. It is not, in fact, the case. The big thing that stands out to me in these decisions is the court's focus on the intent, the application, and the reliance on that direct physical loss or damage language in most, if not all, policies. The decisions demonstrate that these silent policies have credible and persuasive arguments against coverage. I think the decisions will continue to be very fact-specific, and they will have that focus. And I expect that they will be impacted significantly by the precedent rulings that we've already seen. But overall, if we can identify trends that are emerging, I would suggest that those trends are that the courts are finding government closures based on decreasing the spread of COVID-19 do not represent direct physical loss or damage, and that the virus and bacteria exclusions are being found enforceable.
Yeah, a lot of interesting developments, a lot of interesting cases, some interesting rulings. So I'm sure we're just going to continue to monitor and see how the situation unfolds. But, I wanted to shift gears a little bit because AAIS is really unique in the fact that as a national advisory organization, there's a very close working relationship with departments of insurance. Phil, I know you've had ongoing dialogue with departments and regulators around the country. And you actually showed me this map a few days ago. Can you explain to the audience what it's showing and how COVID has impacted regulator treatment of virus and disease exclusion filings?
Absolutely, Joe. This is a very important issue to us at AAIS since we, of course, have our own set of virus and bacteria and disease exclusions that were formally approved nationwide. Nevertheless, we're now seeing that some departments have recently refused to permit new filings or even new adoptions of our previously approved forms. This slide shows the tricolor map where green indicates departments of insurance that, to our knowledge, are still accepting virus, bacteria, and disease exclusion filings without many caveats or restrictions, maybe with some increased scrutiny, but nothing to be alarmed about. Red, on the other hand, indicates 13 departments that have recently refused to accept any new disease-related exclusion filings. They are, from left to right, I'll just go ahead and list them: California, Washington, Nevada, Idaho, Oklahoma, Tennessee, Georgia, West Virginia, District of Columbia, New York, New Jersey, Vermont, and Connecticut. This includes 4 departments: Washington, California, DC, and Connecticut, that are simply placing filings on hold pending further analysis and formulation of what they're going to call an official position. In some cases, though, like West Virginia, for example, these departments are also just prohibiting filings, including adoption filings made by carriers for previously approved exclusions provided by advisory organizations like AAIS or ISO. Notably, I just want to point out that Nevada is the only state that has issued a formal position, and all the other states are still on the unofficial and thus stage without status. The remaining 8 states are colored blue to indicate, some degree of filing resistance that can be anticipated. Hawaii, Delaware, Rhode Island. In these states, filings are only to be accepted for new business. Application to renewal policies is not permitted for as long as the governor's emergency declaration remains in effect. Michigan, there's some maneuvering that needs to be done in order to get commercial lines exclusions approved there currently. It's kind of a shifting landscape, so I'm not going to go into too much more detail currently. And then in 4 more states, it's not prohibited or frozen or subject to conditions, but you can anticipate some significant pushback or scrutiny or objections from Colorado, Texas, Oklahoma, and Iowa. Now, again, with the exceptions of Nevada, this is based on an unofficial, position received either verbally from the department or through filing correspondence, or in some cases just anecdotal reports. So, I just want to provide that caveat here. Just because the state is green doesn't mean you shouldn't expect or anticipate some increased scrutiny, and similar, just because the state is red doesn't mean they haven't changed their mind, an hour ago. So I'll leave with that.
I apologize. The system keeps muting me. I don't know. Maybe it's not liking my questions. But I wanted to put my product manager hat on for a minute and follow up a little bit on that response, Phil, because I'm hearing that there's rejections for new products that have certain exclusions, exclusions that had previously been approved. I'm thinking that's going to muddy the waters from a competitive standpoint for insurers.
Yeah, that's one way to put it. There's a good amount of questionable decisions involved here, and failure to anticipate how locking up a regulatory door, even temporarily, can cause significant imbalance and disparity in the insurance industry. And I think in some cases actually be more harmful to consumers than the exclusion itself, right? I have many criticisms to make on this topic, but there are generally two major points that I've been trying to make to regulators in response to recent objections or other communications. First, just because some carriers are now unable to get new virus and bacteria exclusions approved does not mean in any event that carriers who are already using their pre-approved exclusions within the state will stop doing so. So, most insurers with the benefit of these pre-approved exclusion endorsements will continue to use them, which disproportionately places the risk of a future pandemic or even more localized virus-related loss squarely on a group of smaller, carriers. Many of whom may not have the financial strength to absorb that loss in the first place without the protection afforded by the very exclusion that they're saying is no longer acceptable. Second, there's many more minor points to be made there, but the two major points. The second major point is that regulatory freezes can have a real chilling effect on both program updates and the introduction or expansion of new filings, new lines of business and so forth. So basically, if you're going to have to refile your entire program to add much needed updates or improvements, you may just find a way to wait to do that when facing an environment that makes it difficult for you to maintain a critical program endorsement or component, such as the virus or bacteria exclusion. I think these regulatory freezes and refusals to approve historically acceptable exclusion endorsements really disincentivizes carriers to engage in important program maintenance and expansion to the potential detriment of consumers.
So speaking of muddying the waters, I know the industry was holding their collective breath when state legislators began introducing bills that would effectively require carriers to provide business interruption coverage, regardless of property damage requirements, virus exclusions that were attached to or are attached to the policies. Can you speak to those bills and where they're sitting now?
Yeah, if you go to the next slide, you can see they're still around, and by the looks of things, reproducing. To date, 10 states and the District of Columbia have introduced similar but slightly different versions of legislation that would require some business interruption policies to cover claims made by small businesses related to coronavirus losses. So the DC measure was going to be the first of its kind passed, but ultimately failed to reach a vote in May amid some significant insurance industry opposition. The other bills that are still kind of, technically pending, though the future of them is in doubt with recent closures and of legislative sessions. There's one in California, there's Louisiana, Massachusetts, Michigan, New Jersey, New York, Ohio, Pennsylvania, Rhode Island, and South Carolina. They share a lot of similarities. They're all limited to basically to the small businesses and companies with less than a certain number of employees. The caps range from anywhere from 100 to 250 employees. Many would apply retroactively, some as far back as March even. And then payments made by insurers would be subject to reimbursement from some sort of fund, which would typically be paid into by some identifiable segment of the insurance industry, from as small as companies offering business interruption insurance to maybe just the whole P&C segment, or in some instances, the entire insurance market within the state. Nicole, did you have anything to add?
I think the other thing that I would say is several of the statutes you mentioned seek to set aside the existing policy requirements and exclusions. If you look at Massachusetts, New York, and South Carolina, the proposed legislation would prevent a carrier from denying a claim for business interruption when there was no physical damage to the property. If it was passed, these statutes would strike the policy language that requires that physical loss or damage component to trigger coverage. In Pennsylvania, the proposed legislation would seek to redefine and repurpose the policy language that requires coverage for property damage so that loss of use and business interruption would be construed to include loss or property damage due to COVID-19 and coverage for loss due to a civil authority order related to the declared disaster emergency. The California bills that you mentioned, the proposed legislation there seeks to create 3 rebuttable presumptions affecting cases alleging business interruption due to COVID-19 and that occurred during the period of the state of emergency declared by the governor due to this pandemic. First, with respect to the general business interruption and extra expense claims, a rebuttable presumption that COVID-19 was present on the insured's property and caused physical damage to the property, which was the direct cause of the business interruption. Second, with respect to business interruption due to an order of civil authority claim, a rebuttable presumption that COVID-19 was present on the property located within a geographical location covered by the order of civil authority and caused physical damage to that property, which was a direct cause of the alleged business interruption. And third, with respect to business interruption due to impairment of ingress or egress, a rebuttable presumption that COVID-19 was present on the property of a third party and caused physical damage to that property, which was the direct cause that prevented the ingress and egress to the property and resulted in the alleged business interruption. I think most, if not all, of the proposed legislation comment on the virus and bacteria or communicable disease exclusion, seeking to find application of that language in the policy void. But I guess most important is to remember that this is all proposed legislation, and there's many challenges that are expected prior to any reaching to the point of becoming law. The largest obstacle that many of these proposals face is going to be the constitutional arguments based upon the retroactive application that you already mentioned.
So, we talked about what's going on at the state level, but the fact of the matter is there's similar conversations going on at the national level around mandating the BI coverage, no matter what the policy language. Can you talk a little bit about the federal legislation and where that sits today?
Sure, I can address that. So there's 4 bills there. I listed the HR versions, the House versions. There's some Senate counterparts as well. I didn't list those, but the first 2 there are very similar to what's been introduced at the state level. If passed, they would similarly require insurers that issue business interruption coverage to provide that coverage for pandemic-related losses by, essentially nullifying any applicable exclusions. The carrier would then be allowed to reinstate that exclusion, but only if the insured agrees in writing to do so or fails to pay a corresponding rate increase. Then there's also the Pandemic Risk Insurance Act of 2020, or PRIA, which has been billed as the pandemic counterpart to the Terrorism Risk Insurance Act of 2002, or TRIA, passed after 9/11. We heard a lot about PRIA after it was introduced in the House in May of this year with something like 20 co-sponsors, but then haven't heard a lot since. It's my understanding that's still very much a topic of discussion. There's just other priorities, right? If passed in its current form, though, it would mandate that insurance companies offering business interruption policies cover losses incurred due to pandemics and establish a pandemic risk reinsurance program, or PRRP, within the Department of the Treasury, under which private insurance companies and the federal government would essentially share the responsibility to pay claims for covered losses. Notably, unlike TRIA is actually voluntary. So, why would insurers participate? Well, it does create an exclusive federal cause of action, would preempt any state cause of action against insurers providing this pandemic coverage. Then there's also, or finally on this list, on the introduced bills side, there's the Business Interruption Relief Act of 2020, introduced in June, which is also, sitting in committee like its other bills up there. It would, if passed, though, create a program to reimburse insurers who voluntarily pay those COVID-19 BI claims, despite exclusions to the contrary. So it actually wouldn't apply to policies that don't already contain those virus exclusions, only to policies that do contain them and insurers decide to pay anyway. And then, but just to reiterate, all of these are currently sitting in some sort of committee right now, just kind of waiting. It's unclear how likely any of them is to actually become law.
So when there's the notion or worry that the federal government is going to intercede, oftentimes that breeds innovation in the private sector. Nicole, is there anything noteworthy that you're seeing, innovative products in the private space?
Sure. The last 3 bullets in this slide, I think, call those out. We've got the alternative private party proposals, if you will. The Business Continuity Protection Program, this proposal is supported by the National Association of Mutual Insurance Companies the American Property Casualty Insurance Association, and the Independent Insurance Agents and Brokers of America. The program would allow businesses to purchase revenue replacement assistance through state-regulated insurance entities. The program would be run by FEMA, administrative assistance from private contractors. Businesses would be able to purchase revenue replacement assistance up to 80% of payroll and other expenses, and relief would be automatically triggered and immediately paid following a presidential viral emergency declaration and local closures. The next on that list, second to last, is the Big Insurance Relief Act. This bill is proposed and supported by some of the attorneys involved in the business interruption group litigation. Under this bill, insurers would voluntarily opt to pay claims under business interruption policies that include coverage for civil authority shutdowns, but exclude virus-related damages. And those carriers that voluntarily pay such claims would be provided financial assistance by the federal government to reimburse those benefits paid. And then finally, we can talk about Chubb's proposed pandemic business interruption program, which resembles a pandemic reinsurance corporation proposal. It's a private-public partnership and consists of two programs: one compulsory parametric business income structure for small businesses, and one indemnity-based voluntary structure with traditional claims handling procedures for medium to large businesses. Now, there's a lot of details and nuances in this, and it requires the federal government to share a substantial portion of the risk. And although it's very interesting, this could be its own hour-long discussion. So for those people who are on today's program and who are interested, I recommend that you Google it because you can really do a deep dive here.
Yeah, thanks. Google's good, but sometimes I think I'd rather have Alexa explain things to me. But in all seriousness, we've talked about litigation, legislation, but I do think it's important that we talk about the work that AAIS is doing with respect to COVID-19 and how we're addressing the subsequent insurance concerns. Nicole, maybe you can kind of kick off the conversation about what we're doing in this space.
Sure. I think the first thing that we've got to talk about is the policy language that we've developed and we've had in play for quite a long time. AAIS has, as we've mentioned throughout today's program, our own virus and communicable disease exclusion endorsements and policy language. The provisions are applicable in all lines of business that we offer. And our first step during the early stages in this pandemic was to review that policy language with a focus on the exclusions and on the policy language and provide guidance to our members through policyholder notices and memos. As we've already discussed with regards to the way that the case law opinions and orders are trending, we continue to remain confident that these exclusions are effective, and based on our prior discussions, will hold up in the current pandemic environment, absent targeted legislation or new regulatory filing obstacles. The next thing that I would want to touch on is to let everyone know that AAIS collected all of the information that we reviewed and all the resources that we could find to provide one place where our members could go to access all of that information. We created the AAIS COVID-19 Pandemic Resource Center, and as we showed you earlier, developed the COVID-19 Coverage Litigation Tracker and Heat Map. All of the information and the links to these programs are on the next slide and will be provided to everyone once we have completed the presentation today. Phil, what do you want to add?
Yeah, so the two items in bold there that in the middle of the slide, we began to consult with regulators and outline some policy resources that we thought could be of help or use to our members and the industry at large. And so we quickly developed a handful of sample policyholder notices and a suspension of cancellation endorsement for our members to adopt and imitate, especially in states where cancellation suspension was a matter of compliance rather than merely a suggestion. Just earlier this week, we made those resources available to the public, not non-members. And as Nicole mentioned, we'll actually provide copies of those along with the slide deck after this presentation. We're working on other solutions too, but I think it's probably more appropriate if I kick it back to Joe as product manager talking about product development. Joe?
Yeah, thanks, Phil, and certainly this this is important work because the insurance industry is playing a big role in this pandemic. So from a product standpoint, we've developed a prototype of a supplemental coverage that could be offered on policies already providing ordinary business income coverage. The supplement offers a limited form of emergency business interruption coverage for expenses and costs related to a public health crisis, all without that pesky requirement of property damage. We're in the process of finalizing that endorsement and hope to have it available to our members in the coming months. But it's not intended to address this crisis, but rather the next one. And then, finally, we are working diligently to create the first standardized parametric insurance policy that would provide gap coverage for a variety of exposures, including pandemics. We're definitely taking our time to get this particular product right because in our discovery phase, we've realized that a lot of people are talking about parametric insurance, but don't have a full comprehension of how it really functions. And the policies and programs currently on the market can be confusing. And at AAIS, we're focused on coverage language that can be read and understood by the policyholder, not the insurance geeks like myself. But we're really on a mission to demystify parametric insurance with common sense coverage triggers, recognizable standard coverage terms, and I guess maybe one of the more important aspects, reasonable rates and loss costs. So a timeline on release of that product where we're targeting early next year. So, that really concludes today's session. I'd really like to thank our attendees, and if there's any questions, please ask. But a question that I know that I see here is around parametric insurance. And Phil, can you elaborate on the parametric? I said, demystify this parametric product. Can you talk about that a little bit?
Sure. Yeah. Well, I'll do that. Why don't you jump over that last slide? Contains some contact information and everything. So with some exceptions, traditional insurance is designed to cover an isolated loss and fully compensate the injured party, or at least as close as possible. It has its hiccups, and unfortunately, often encourages a litigious relationship between the carrier and the policyholder, especially for large losses. Because of this, it can sometimes take months or even years to resolve large claims, and traditional insurance is just not designed to quickly put money in the hands of policyholders during a crisis. So they continue to operate and, avoid going out of business. Also, the nature of pandemic risks, they're widespread, they're fast moving, they're unpredictable, and the nature of pandemic business losses, mostly economic, extremely fact specific, sometimes very difficult to verify, make pandemic coverage extremely messy and in many cases impractical or impossible, at least in the traditional sense. So parametric insurance gives you a tool to solve all or most of these problems. First, it lets you, tie coverage to a verifiable and objective source of information, removing or at least reducing the need for trust in the policyholders themselves. And both parties just agree up front that, if this trusted third party says a covered loss occurred, then a covered loss occurred. No need for extensive, verification or claim adjustment expenses or protracted litigation. And second, it lets you issue payment to the policyholder, not for the entire loss perhaps, but for enough money and with a quick enough turnaround that may make the difference between staying in business and going out of business. And then finally, it lets you, insure losses and expenses that just don't fall neatly within the scope of traditional insurance. As I said before, it doesn't really have to be any direct physical loss requirement. In fact, there's some, sometimes it doesn't even have to be any traditional loss at all. The question is whether a loss event occurred, not whether a loss occurred. So I'm oversimplifying it all to a degree, but I think the point is that parametric insurance is uniquely suited to spread the risk of widespread catastrophe, especially when approached with the understanding that it is not intended to fully compensate the policyholder, but rather to provide that emergency funding to help weather the crisis.
Yeah, it's definitely interesting stuff. And to the audience, please feel free to unmute yourself, and I'd like it to put it out there to the audience and see if we have any questions. No? Okay.
While people are thinking about questions, Joe, we should also draw their attention to that in the slide that you have up, the AAIS, oops, sorry, if you go back one, there you go, AAIS resources, the third slide, the third link down there, the virtual main event video. In that presentation, we really went into the history of P&C policies, and we talked about how these pandemic risks were not historically intended for coverage. And that really goes to Phil's point about understanding what the policies were intended to cover and why this parametric solution is necessary now.
And that last bullet point, if we're pointing out stuff on this slide, the last bullet point is a link to register for our AAIS Pulse, which there'll be a ton of information presented there, not just on COVID, but on a variety of topics, including cannabis and auto and all kinds of fun stuff. So yeah, after we pass these slides out, if you want to check that out and register, it's going to be a pretty great event.
Yeah, I definitely encourage everyone to check us out if you can. So with that being said, again, thank you to the AICP for allowing us this platform, and thank you to our audience.